now in session.
Morning. Please be seated. This is a time set for oral argument in VR versus Staubach, our cause number 1CA CV130504. I'm sure counsel are aware that we've read the briefs, we've read the record, we are quite up to speed on the case and have discussed it before coming in this morning, so you can bear that in mind. We are being videotaped, and eventually this argument will be posted on YouTube. So if you would do us the favor of announcing your name and that of the party you represent when you approach the podium, we'd appreciate it. Each side has 20 minutes for oral argument, and the appellant may reserve as much time as it wishes for rebuttal, but you're responsible for watching your own clock. And with that, we'll begin.
Thank you, Your Honor. Robert Stoll and Ann Tiffin of Dickinson Wright for the appellant's Staubach Retail Services. We've put in front of the court, through the court's clerk, a glossary of terms that are used throughout the briefs and will be used today so that we can kind of avoid time. That's been provided to the appellees also. This is a business divorce case. Unfortunately, and what we're here about, is the trial court divided property not owned by the divorcing couple. The property was owned by a company, in a different company, to which one of the divorcing parties had absolutely no interest in.
But isn't that simply the measure of damages, not the source?
No, Your Honor, because the measure would be receipts of a company that was not covered by the reorganization agreement.
Is it the receipts, or is it simply a calculable sum that the court ordered to be paid?
Your Honors, it's actually receipts, because it would be that would be 45% of the house share with no burden or responsibility for overhead.
Well, that's a very different argument. On the one hand, you're arguing that it's the wrong party, and on the other hand, you're arguing that there's a calculation error. So
we are doing both, Your Honor.
Okay. So let's stick with the party argument for a second. If you and I have a dispute and our contract provides that the measure of damages will be the receipts of Apple Inc. for the 5 minutes beginning at 9 o'clock this morning, it may not be a party, but why is that not a calculable measure of damages?
Because it doesn't because the California receipts were never included, because the operating agreement of SRS West was never amended to increase the territory to include Southern California.
So we're back to the merits and off the party due process argument.
On that, yes.
Okay.
I mean, but there has to be a right to participate in Southern California's receipts.
Well, not necessarily. I mean, the court can simply, let's say the court just simply ascribes a number to it and bases it on, something in the Farmer's Almanac, and says you're going to pay a sum that is consistent with a calculation of this times this. It doesn't necessarily mean it's coming from the entity.
But then where in the reorganization agreement does it say that? And it doesn't say that at all in the reorganization agreement, that the receipts of SRS Southern California are to be divvied up 45-55.
And that's, I think, where the whole oral modification argument comes in.
Then and as to that, we have Delaware parole evidence. Are we modifying the reorganization agreement? And the reorganization agreement, and lots of time was spent on the briefs, it's a fully integrated document. And
with regard to the scope of the document, I mean, it
Yeah.
can only be integrated with regard to its subject matter.
And the scope of the document was attempting to resolve all matters between between SRS partners and the then VR partners as to their ownership of SRS West.
Why didn't the agreement say that then? All matters. Why would it say related to the subject matter?
Well, I don't have an answer for that, Your Honor.
I mean, but don't
I
we have to assume then that there's some reason, or we read contracts according to their plain language? You're asking us to read into the contract all matters, that it covered all matters.
Well, but the subject matter was all matters. Excuse me. It says all matters. The subject matter was the dividing up of SRS West. That's what was going on by the reorganization agreement. It was to reorganize the business. And if we go to the joint pretrial statement, it says in the joint pretrial statement that SRS and Velocity decided to part ways and begin negotiating a reorganization agreement in lieu of exercising the buy-sell provisions of the LLC agreement.
But none of that addresses the contention that there were oral modifications. I mean, all you're doing is choosing between two written agreements which are limited in scope.
Well, there's never been a contention, to my recollection, Judge Swan, that the reorganization agreement was orally modified. They're not contending that.
But it is your understanding that the LLC agreement was modified.
They contend that the LLC agreement was orally modified, and
then the question is whether the reorganization agreement, by virtue of its integration, prevents the oral modification of the LLC agreement, right?
understand that fully.
Okay.
But
Didn't
you also participate in the redistribution of the percentages of distribution?
I'm not sure.
Wasn't there a course of conduct by your client that recognized?
My client never recognized that the Phoenix office participated in the Newport Beach office. Newport Beach suffered a loss. That is the only testimony in the record, is during the time that these parties operated SRS West, Newport Beach was suffering a loss. And that loss was not charged against Phoenix.
Well, you're very specific as to what they didn't agree to. Are you saying that there was no oral modification of the contract that your client participated in?
The court determined below that there was an oral agreement to provide to VR something in Newport Beach. That's what the court determined below. The court didn't determine that the operating agreement was orally amended. I don't believe that's in any of the findings of facts or conclusions of law. The court only said there was an agreement. There was an agreement with a party or about a party that was not a party to this litigation. That's SRS SoCal. Circling back to the parole evidence, again, we contend that, and it's undisputed, I believe, that these are agreements that are both the reorganization agreement and the operating agreement. These are agreements to be construed under Delaware law. I do not believe that Velocity disputes that contention. The Delaware law is, shall I call it, the more traditional view of parole evidence as opposed to Arizona's much more liberal view of parole evidence. I think, and it's set forth in numerous places in the brief, both the brief and the reply brief of my client, that what the appellee is attempting to do, and certainly did in the trial court, was to introduce inadmissible parole to vary the terms of the operating agreement.
And you're saying that the parole evidence was inadmissible because of the integrated reorganization agreement?
Yes.
Okay.
And Delaware, obviously, and Delaware law. I mean,
But doesn't Delaware law prescribe a parole evidence rule that prohibits oral modification of integrated agreements to the extent they are within its scope In other words, the mere fact of an integration clause doesn't displace all parole evidence for all time. It displaces the parole evidence that falls within the scope of the integrated writing.
That's correct.
And for whatever reason, the reorganization agreement appears to fall short of a full reorganization, which I admit is puzzling. If you're going to do a reorganization agreement, you'd expect it to be comprehensive, but this one seems a little more modest.
Well, Judge Swan, you and I both have perfect hindsight, and neither one of us were in the room when it was being negotiated. I wish I was there knowing what I know today.
Right.
But this is where we find ourselves. But when one says that something is missing, it is it's my client's contention that it was never part of, so how could it be missing? And that's Newport Beach. That's the only thing that seems to be missing, because pencils were counted, square footage was counted, everything was counted and specifically dealt with to great minutia regarding the Phoenix office. Mm-hmm. But as to the Newport Beach office, there is clearly nothing in the document relating to the Newport Beach office at all. The only way the Newport Beach office could possibly get into the document is for Newport Beach to have been part of the territory in the operating agreement. That's the only possible way it could get into the reorganization agreement. But I think it's clear, and again, I do not believe that the appellees are contending that Newport Beach is called out in the operating agreement. With that, I'll reserve the balance of my time.
Good morning, Your Honors. Thomas Hudson on behalf of the plaintiffs' appellees. Your Honors, this is a case about a party seeking to avoid a clear obligation on the basis of legal technicalities that have absolutely no application whatsoever. And unless the court would prefer that I proceed differently, I plan to touch just briefly on each of the issues raised in the appeal, and then if I have time, just talk briefly about attorney's fees. With respect to the first issue, the face of the judgment obligates only the defendants in this case. And if they had any issue whatsoever with the form of the judgment, they certainly should have made an objection to the form of the judgment, but they not only failed to do that, they stipulated to the form of the judgment. And of course, we know...
You raised the issue, I believe, in your answering brief about whether or not they had standing to object on behalf. Is that correct?
I did. Yes, we did.
Can you tell me about that?
Yes, Judge Jones, and certainly that's not one of our central arguments, but...
Is there a standing issue is my question.
Here's the point. What their argument is that the judgment purports to obligate a non-party. So you look at the Hazeltine case, for example. That judgment identifies a non-party, and then the non-party has an issue with it. Here they're saying this purports to impose obligations on somebody who's not even here, and we questioned, well, why is that there? How are they able to raise that issue? But I think the more fundamental issue that I want to make is you look at the face of the judgment, it only obligates them.
Are you trying to collect it against the non-party?
The judgment doesn't purport to impose any obligation on any party other than the defendants.
So the judgment is collectible solely against the named defendants?
Absolutely, and there's a bond posted for it by them.
Thank you.
And of course, we know, too, and then I'll move on, but we know that a central issue at trial was whether the documents had been updated to reflect the agreement. That was tried to Judge Hagee, and he found that, in fact, the documents had not been reflected. So it's a little odd to then go to the Court of Appeals and say, here's a document and this is the real deal, when that issue was tried to the Superior Court. And unless the court has more issues on the judgment issue, I'll turn to the parole evidence issue. Our view is that there's absolutely no parole evidence issue at all, precisely for the reason implicated by the questions from Judge Swan that the scope of the reorganization agreement had nothing to do with region. In fact, Kiesling, who negotiated on their behalf, testified in the Superior Court that in order to determine the region, you needed to look at the LLC agreements. He was asked, for the judge to determine what region is owned under the reorganization agreement, does the judge have to go back and interpret the LLC agreement? And he answered yes. And so I think what that shows is it's not a standalone agreement. That agreement was predicated and only worked by looking at the LLC agreements. And I guess to top it off, this wasn't a point in our brief, but it was argued below that after the reorganization agreement, the defendants provided the existing deal list that Judge Heggie and everyone seemed to agree at trial they were obligated to do. That existing deal list included Newport Beach. So you have a writing after the reorganization agreement that identifies Newport Beach as the region over which the parties are going to split these revenues. Unless the court has questions on that. Promissory estoppel is the same issue. I don't really have anything to add on that. There's no express contract in the reorganization agreement dealing with region that could be in any way contradicted by the party's course of conduct. Again, it's a classic case. As Judge Heggie found, the plaintiffs were repeatedly told that the parties' agreement would be reduced to writing, and it never was. So it's sort of a paradigm example of where promissory estoppel is appropriate. And I guess...
Well, let's talk for a moment about the implied covenant. There does seem to be an awful lot of flexibility in the deal as your side envisions it that allows each side to sort of change the expectations of the other. Doesn't there?
The reorganization agreement did provide the parties some flexibility. Just wanted, and on specifically with respect to the house split, Judge Heggie specifically found that the parties intentionally left that provision flexible. That's paragraph 30 of his findings. In other words, he found that they intentionally omitted anything about how the parties were going to pay their brokers on a going forward basis. And I'll admit, Judge Swan, the evidence was conflicting. There was evidence on both sides, but there was evidence that Velocity decided to change its house split at the outset before before there was any contention that they were entitled to the commissions on new deals. There was evidence that both sides believed it would have been improper to dictate how they would have paid their brokers and done the house splits on a going forward basis.
But it does then, I mean, if that's the arrangement, it does invite an argument that the covenant of good faith and fair dealing is being violated potentially every day, right?
I think what you would need, I mean, suppose, Judge Swan, that the day after it, they changed the House Commission to 0 and they had no business purpose for doing it and there was no other evidence to the contrary.
Or even 1%.
Yeah, only 1%. Then you might have, then you might say, okay, the fact finder maybe should have found that. But here we have, there was business reasons for doing what they did. The defendants changed their own house split without telling our side. And again, there's mixed evidence about whether that ultimately affected the payments, but they weren't making payments. And then what they did was sort of consistent with industry practice. They adopted what they called the Lean Associates model, where they paid their brokers a higher percentage to bring in more people and grow the business and so on. So it wasn't sort of something so dramatic or inconsistent with business practices. And I would also just note, they're not even challenging Judge Heggie's finding with respect to what the parties intended with respect to the contract. And again, David Kiesling, who negotiated that contract on their side, said that it was both sides' prerogative to change the house split after the reorganization agreement.
And that they both did so. So we would submit that in light of all of that, this court can't conclude that Judge Heggie committed clear error by making that finding and rejecting their breach of the covenant of good faith and fair dealing argument. And unless the court has further questions on the appeal, I'd like to just say a few brief words on the cross appeal.
with respect to fees. It is true that this fight came under the reorganization agreement, but inextricably intertwined with it, as I've just noticed, just explained, was the LLC agreement. And the fight was, there was a principal fight over whether that was orally amended. So I think the clause in the LLC agreement does come into play. And then the question is, what does the provision in the LLC agreement mean? And we submit that it means, at the end of the day, it means that the prevailing party is entitled to fees. And I know it has the word in there, the arbitrator.
It's not just the word, the arbitrator. It's an arbitration clause that the parties chose to waive. How do we get around that?
So, and I understand that, Judge Swan. And the best answer I can provide you, I think there's 2 points that go to it. One, it seems somewhat odd to say that parties can waive arbitration, and that happens all the time, and that even though they've agreed to fees, once they do that, then they also waive fees. But I think more important to this case, and the facts of this case, the bottom line question is, what did the parties intend? And our position is the parties intended the prevailing party to get fees. And how do we know that? Both sides asked for fees below. Both sides asked for fees on appeal. So we would submit that when you look at what actually happened in this case, it's the better conclusion is that the parties intended the prevailing party to get fees.
Well, you also ask not only under the provisions of the contract, but under 12-340-101, I noticed.
I don't think our side did, Judge Brown.
On appeal? No, not on appeal. I can tell you did on appeal.
Oh, did we?
On both
Okay.
sides. And I believe it was in the Fourth Amendment complaint.
Okay.
But, I mean, do you concede that that's not Delaware law?
It's
right?
not
That's
Delaware law. I agree with that, Judge Brown.
Okay.
Yeah.
So 340-101 doesn't apply.
Unfortunately not.
Okay. And the fact that both sides want fees, how helpful is that in considering their right to fees?
Well, that's what we call an agreement. Right, when both sides say we want fees if either side prevails, that's a stipulation. That's another name for an agreement.
Do that in jurisdictions that don't have fee shifting statutes. They always want fees. But your desire is not necessarily your agreement, and the agreement is specifically for delegation of that authority to a person who didn't serve in this case.
I understand that, Judge. And again, what I would say is the best answer I can offer you on that is that here you have that provision, and then you have the conduct afterwards, and you have which in our argument is that shows what the party intended with respect to the clause. And when you interpret provisions, that's the bottom line question. What did the parties intend? It's in there. They asked for fees, and I have nothing further on fees unless the court has more questions.
Your Honor, the lack of a fee provision in the reorganization agreement should be dispositive. We tried a case regarding the reorganization agreement, and there's no fee shifting provision.
What do you do with the argument that both sides asked for fees?
We were both stupid. We both asked for something that a court did not have any jurisdiction to give.
No, it's very candid.
Is there any argument to be made that if we applied Arizona law, that we could just automatically proceed under the language of the statute of 12-340-101 and award those fees?
If we were dealing with Arizona law, 12-340, this is a contract dispute, 12-340-101 presumably is applicable, but that's not where we're at. And that's not, my colleague here acknowledges that also. We're not here under 12-341, whether we've asked for it or not.
My point would be that if, out of an abundance of caution, the parties simply put it in there, assuming that if the court didn't buy into the Delaware law controlling the issue of fees, then they'd reserve or preserve their right to fees under statute in Arizona. I mean, is that possible?
I guess it's possible, although unlikely, because I think whoever, frankly, if the trial court then awarded fees under 341.01, we might be up here arguing that that was beyond the court's jurisdiction because there was no contractual right to it. The parties and that both parties may have asked is not a stipulation. It's clearly not a stipulation, and there was no order for that. So that's dealing with the fee issue. Regarding the house splits, I think it's not at all what was suggested by the appellee in its oral argument. Regarding the splits change by my client, the SRS split change, the only testimony is that, yes, there were split changes, but there were no split changes on transactions in which Velocity had a right to participate in. That is the only testimony before this in the trial on that topic. We did not change any splits on a deal that they had a right to participate.
But the agreement was charitably put vague on what house splits would be, right?
I think that's fair. That, again, we're dealing with good faith and fair dealing.
And it's, that creates a problematic situation. I can sympathize with that. But then aren't we bound under Rule 52? Judge Hagee would have had to have gotten it very, very clearly wrong for us to act.
But let me, well, to respond, the appellees were trying to bootstrap SRS's fee change, split change, to justify their split change. That's what just occurred. And let's talk about their split change. You heard that their split change was created because of the lean associate model. But the only testimony in the trial is the only Velocity brokers who had a split change were Messrs. Cheatham and Pitts. No other broker had a split change. So the hired brokers who had no interest in the company, their splits were still in the more traditional 45%.
But how does, go ahead.
I recognize the argument. I hear it. But under the standard of review that applies, how do you get to a clearly erroneous finding? Even if we agree with you, even if your argument sounds more plausible, under the rules, how do we find a clearly erroneous finding?
I think that the court could find the testimony of Messrs. Cheatham and Pitts as to the justification was just misread by the Judge Hagee just misread and misheard and misunderstood the testimony of Mr. Cheatham and Mr. Pitts. That's the only way, but you have to make that conclusion that the judge has got it wrong.
How do we get there? I mean, Judge Hagee heard it. He made a finding. His finding may be debatable, but how can we say that he misheard it?
I don't have a good response to that, Your Honor.
Okay.
But, and appellees also attempt to somehow modify the reorganization agreement which was dated in May of 2009, is my recollection, May 9 of 2009, by what was referred to in the trial court the kitchen sink list, which was delivered sometime in December 2009. And somehow that modifies the agreement. Well, there's been no finding in the trial court that the delivery of the kitchen sink list modified anything.
Well, isn't it more along the lines of corroboration for this?
Well, except the testimony regarding the delivery of the kitchen sink list is, this was from Clay Smith, I want a list that contains everything, whether it's relevant or not. That's the gist of the testimony. I don't want to suggest this as a quote. I give them a list that contains everything that ever happened in the Phoenix office, whether it's alive, dead, these offices, whether it's alive, dead, or otherwise. They want to see it, just give them the list. That was the testimony of Clay, the gist of the testimony of Clay Smith when it was delivered. If the court has no further questions, I have nothing else, Your Honor.
Thank you.
All right, thank you very much. Thanks to both sides for their arguments. The matter is now under advisement. We will issue a written decision in due course, and the court will stand in recess to allow the next argument to get set up. Thank you.